Mr. Gopal, you are on mute.
सर हेलो सर, आप अनम्यूट करिए प्लीज। आप अभी म्यूट हैं सर।
I'm audible, ma'am, now?
यस सर।
Okay, ma'am. Just
No audio, please.
I am yet to begin, sir. Just give me a minute.
Okay.
Good evening to all of you. I am Srinivasan Gopal. I'll be deep diving into the provisions of NDPS Act, and you can interject me at any point of time for any clarification. So with that, I will begin my session. And this way we will be covering into different aspects. One would be the foundation and the definition part of it. The other one would be part two, would be covering the authorities and offenses. The third one would be the search, seizure, and evidence, and that would be the most crucial to it. And I emphasize here at the beginning itself, the seizure, any amount, irrespective of the amount, doesn't qualify or doesn't translate into conviction. See, the quantum of seizure doesn't qualify or doesn't merit the prosecution getting a conviction. And that should be very clear to you. This is a very different act from any of the other criminal acts which you would be implementing. The fourth portion would be the trial, contemporary issues, and practices on the subject. So basically, you'll have an overview of the entire thing. So with that, I begin my first foundational aspects of this particular thing. Now, to understand the foundation of this particular act, this act is primarily based out of when it was enacted in the year 1985. It was based on India being a signatory to the 1961 and the 1971 convention, and the provisions of the 1961 and the 1971 conventions were mirroring in the NDPS Act of 1985. Even though we were signatory in the year 1961 and 1971, we had a leverage of 25 years, and hence we had the time to enact this. And the year 1985 was the year when it came into existence on 14th November 1985. The 1961 convention, which is the basic one, which deals with single convention. The title is single convention. It means that whatever conventions and codes were earlier available were codified into a single one, and a uniform structure was created, the uniform convention was created, and that goes by the term single convention. So everything came together, and it dealt with primarily narcotic drugs, except for scientific and medical use. The next convention was in the year 1971. As we progressed, as we tightened the noose on one end, it gradually shifted to the psychotropic substances. And we find that this was also addressed in the year 1971. So India has been signatory to both the conventions, and these provisions are mirroring in the NDPS Act. So before we delve deep into it, so we will have to know a little bit of what is narcotic drugs and what is psychotropic substance. And do not confuse the terms with the medical terminology you'll be coming across. So that would be totally different from the Act. It means narcotic drugs would be such of those drugs which are covered under this Act, basically plant-based drugs, primarily plant-based drugs based out of cannabis plant, opium poppy, and the coca bush. These are the three one from which we get. Anything which is derived from here would be called narcotics. As we progress, we have had synthetic versions of the main ones. So these are basically, this could be used as a painkiller. It could be put into use in different forms. For example, we have codeine, which is acting as a suppressant. We have morphine, which would act as a painkiller. So this narcotic drug would be used in that context in the Act. As against this, the psychotropic substance would be mind-altering substances, which are primarily manufactured 100% in pharmaceutical companies or in clandestine laboratories. So they are mind-altering substances. So it could be a whole lot of substances which are getting covered. And in the psychotropic substances, we would also have substances which are covered under the provisions of the Drugs and Cosmetic Act. Particularly, emphasis would be on the correlation of Schedule H1 drug under the NDPS, under the Drugs and Cosmetic Act, which have been notified for the purpose of the NDPS Act. So there is a dual war on that. So as we progress, we saw that these two were not enough. And we come to the year 1988, where we see that the precursor chemicals, the chemicals which go into the manufacture of the narcotic drugs or psychotropic substance, were brought well within the ambit of the 1988 convention. These two precursor chemicals, a lot of precursor chemicals have been notified in the Indian context. As of now, it is 46. But essentially, ephedrine, pseudoephedrine, potassium permanganate, acetic anhydride were the main ones at the material point of time, which were brought into the ambit. And these have their own legitimate use, but they would be siphoned off into the market for illegal manufacture or illicit manufacture of narcotic drugs or psychotropic substance. Just for the sake of illustration, for example, acetic anhydride has its multiple uses, not only in dye industry, textile industry, perfume industry, etc., but it is also diverted for the purpose of conversion of morphine into diacetyl morphine. Diacetyl morphine is locally known as heroin. Similarly, potassium permanganate, which is otherwise used as a water disinfectant, can be used for the purpose of processing coca leaf into cocaine hydrochloride. And similarly, you have ephedrine, pseudoephedrine, which go into the manufacture of methamphetamine, what we see across the North Indo-Myanmar border. So
Sir,
these
slide is not showing, sir.
Slide is coming, sir?
Yes, sir.
Something there is some issue in slide.
Is it visible, sir?
Visible but not
visible, sir.
Sir,
moving.
it's visible, but
Still
slide
visual.
is not moving.
there, but it's not moving.
Slide is not moving.
No, it's not moving. It is static. I have not moved the slide. It is all the three conventions are static. I have not moved the slide.
Okay.
I have not moved the slide. It has three components. All the three. I am explaining all the three components of the convention: 61, 71, and 88. Ma'am, can you ask the participants to mute their mics? There's a lot of echo coming in. Now there are.
Okay.
आवाज आ रही है पीछे से echo आ रही है, please. Participants can please mute yourself so that everybody gets a clear audio. This is a static. This one we have three conventions to which India is signatory. I have been explaining all the three here by one followed with other. It starts with 1965. I repeat it for the sake of better understanding of other participants who have lost it. 61 convention is termed as single convention on narcotic drugs. Primarily, I'm focusing on the word single because of the fact that all the previous conventions were pulled together. They were amalgamated to formulate into one single code, which is called the single convention. All the earlier ones were just put together, they were codified. And since a lot of conventions were codified into one, it became a single convention. So it dealt with narcotic drugs except for scientific and medicinal purposes. So anything which is used other than scientific and medicinal purposes got covered under the 61 convention. So then gradually we see the psychotropic substances of 1971, and that dealt with the mind-altering substances, and it is basically lab or pharma company oriented substances. Now, between narcotic drugs and psychotropic substances are mind-altering substances, as against narcotic drugs in the context of NDPS. I'm only telling you in the context of NDPS Act and the Indian version of it. And participants be aware of the fact that what is narcotic drugs in the context of in the NDPS Act would definitely be a psychotropic substance in the act of any other country. So variations would be there. So I'm only focusing on the legislation of our country. So narcotic drugs, basically, if you see morphine, which is derived from the opium plant, it is a painkiller. If you happen to see codeine, it is obtained from the same plant, it is used as a suppressant. So narcotic drugs in the context of the plant, it would be used as a suppressant, it could be used as a painkiller. So basically you can say it is a painkiller. Then we graduate to 1988, we see the India becoming signatory to the UN Convention of 1988, which primarily focused on precursor chemicals which are used to manufacture narcotic drugs and psychotropic substances. Now, in the context of India, it is called controlled substances. Why we call it control? Because the manufacturers or importers or export, as the case may be, they will have to get themselves registered for the purpose of manufacture or for the purpose of export or import, and that is being regulated by the government via the Narcotics Control Bureau for Schedule A substances, or for export or import by the Central Bureau of Narcotics, Gwalior. So we have exercised control over these units. So the term is controlled substances. So these are the three legislations, the international conventions, which find mention in various forms in the NDPS Act. So these conventions basically mirror the NDPS Act of 1985. Now, why this becomes important for our, this one is, this constitutional aspect, if you happen to see, is covered under Article 47, and which categorically says that the state shall endeavor to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and of drugs which are injurious to health. So here also anything which is for medicinal purposes is exempted, but the state shall endeavor to bring. So that is how the state gets involved via the Director Principal Policy. Article 47 comes into play. Now, in the context of this act, prior to 1985, we did have a lot of acts. Basically, the Opium Act of 1857, followed by 1878, and the precursor to the NDPS Act was the Dangerous Drugs Act of 1930, which did rule over a period of time. But these acts enacted during the British era were not self-sufficient and were not addressing the issues of. So basically, subsequent to the India becoming signatory to all the three conventions, primarily the first two, we had the obligation to enact a law, and that is how the NDPS Act did come into force. And the other reason, was primarily because of the strategic position we were in. We, on the eastern and the western front, we are surrounded by the Golden Crescent and the Golden Triangle, since renamed as Death Crescent and Death Triangle by the Honorable Union Home Minister very recently. And in that context, India is sandwiched between the death crescent and dread triangle, which brings in drugs into the country. So that is the historical context in which we do it. And what happens in this act is there is strict or stringent deterrence, and there is medical and scientific regulation. In case of requirement of medicinal and scientific regulation, that's a different obligation. As far as this point 1 is concerned, it explicitly prohibits and penalizes cultivation. You cannot cultivate opium poppy, you cannot cultivate cannabis, you cannot cultivate coca plant. So it expressly prohibits cultivation, and opium poppy is being legally cultivated in our country under a proper license. Legal cultivation is allowed. One of the few countries where legal cultivation is allowed. Now, the structure of the act, and this is more important for you to understand. And the first part would be the title and the definition, and definition becomes extremely important. And each of the definition, be it addict, be it small quantity, be it commercial quantity, be it control delivery, be it psychotropic substance, be it narcotic drugs, be it illicit traffic, are to be read very carefully, because the definition plays a vital role here. So you will have to read the definition carefully and thoroughly. And there are authorities and officers here, and this act has been enacted by the parliament, but has been implemented by the central government as well as by the state government. So it's one of the legislation. It is just like similar to the taxation, we have the GST here. The same thing enacted by the union government, but implemented by both. So as far as central government is concerned, we have the Narcotics Control Bureau, we have the custom formation, primarily the Directorate of Revenue Intelligence, the custom formations at the seaport, at the foreign post office, at the courier, at the international airports, etc., spearheading the implementation of this. And we have the Central Bureau of Narcotics and certain paramilitary forces like the SSB, the BSF, the Assam Rifle, that's a new entrant to the list, who would be performing their duties at the jurisdictional level. Now, apart from this, the police, except for the Delhi police, which comes under the Union Home Ministry, rest of the state police would be under the respective state governments. They would be doing it, and along with the revenue officers and the state drug controller or the prohibition, the excise departments of the respective state governments, depending upon the notification issued in this regard. So it is an amalgamation of the officers from various departments, and you can see the almost size of the organization which would be coming together for the purpose of implementation this particular act. Apart from that, when we move to part 3, we have this prohibition, control and regulation with reference to licensing regime, governing cultivation, governing manufacture and trade. So I will not be focusing more on that, but the offense and penalty portions are the graded punishment which has been introduced in the year 2001 when the amendment was carried out as far as the penalties are concerned. Now the procedure which has been set out here is the crux to the entire act. This particular chapter 5 is extremely important. The offenses would be only known when the procedure set out is known, the quantum is known, the mandate which is fulfilled for the purpose of this one. It starts with 41, 42 and 43. I will be focusing on 3 sections, 41, 42, 43 for the purpose of this presentation. 41, which gives the power to issue search warrant and search authorization. Such warrants are issued by the judicial officers, and it is covered under 41 subsection 1, and it is based on the evidences which have been placed by the empowered officers before the judicial first class magistrate. Now, this becomes extremely important because it is the AMC who is authorized. It's not all the magistrates are authorized to issue search warrants. Do not confuse the term search warrant with search authorization. Authorization is issued by the officers who are of the gusted rank of the empowered departments. By empowered, why I am stressing on the word empowered officer and empowered department is there is a set of departments. If you happen to see 42, they have been authorized to implement this act. Such are those officers who are authorized to do it are empowered officers. The departments to which they belong are empowered departments. Participants, can you mute yourself because it is echoing? Now, this particular, it is not that every department is authorized. It is the departments which find mention or being notified are the only departments which are capable of implementing it. For example, the Enforcement Directorate or the Income Tax Department are not authorized to implement this. Should they come to in touch with their search operation, they cannot book a case. They will have to pass on the information to the respective jurisdictional authorities, be it custom, be it NCB, be it police, wherever they are located, the nearest department. So the word here is empowered. As in a slight deviation, digression from here, in the fiscal statutes, we have proper officer. Here we use the term empowered officer and empowered department. It is these officers only who can do it. So the empowered gusted officer whose departments are mentioned in section 42 can issue a search authorization based on the intel note along with the evidences which have been placed by the officer empowered under 42, and on the basis of reason to believe arrayed based on the documentation, they would be issuing a search authorization. And the search authorization would be issued in favor of one single officer for the purpose of search. Now, the search can be divided into two broad categories. One category is between sunrise and before sunset. That is one category. The next one would be between sunset and sunrise. If the search is to take place after sunset, there is an additional requirement which has to be fulfilled by the empowered officer. That is, he has to record the grounds of belief as to why that search operation is required. And this being a strict liability act, non-compliance of any of the provisions would be fatal to the case book. It is, I'm emphasizing once again, it is not the quantum of seizure which would get a conviction. It is the compliances of all the mandatory provisions which have been held to be mandatory by the Act as well as by the Honorable Supreme Court. They have to be complied in the strictest form, and a single mistake would only derail the entire case. So this particular provision of 41, which gives power to the judicial first class magistrate under 41(1) to issue search warrant, and under 41(2) to the gusted officers of the empowered department to issue search authorization. So this is two portions to it. 42 is dealing with non-gusted officers of the departments mentioned therein. It could be from the state, central government, it could be the officers of the rank of sub-inspectors in the NCB and above. In other CBIC formation, that is the Central Board of Indirect Taxes and Customs, it is the inspectors and above, and inspectors would be known by the place where they are posted. In different places, the designation keeps on changing. So it is, broadly, it is inspectors, and in case of Central Bureau of Narcotics, Gwalior, it is sub-inspectors and above, and other paramilitary forces, depending upon the authorization, it varies from organization to organization. The RPF is there, the SSB is there, the BSF is there, the Coast Guard is there, and a special mention with reference to Coast Guard. In respect of Coast Guard is only the gusted officer who have been empowered, and there is no non-gusted officer here. So it's a marked difference. So I'm emphasizing that the notifications support your case. Now, 42. 42 is dealing with, apart from the empowered officers, it also deals with enclosed place. Enclosed space, it means that you wish to go to a residence, you wish to go to a, say, a unit which is enclosed in character, that would get covered under the broad ambit of section 42, as against one which would be public space. It means that vehicles in transit or in movement in the open area. So enclosed area would get covered under 42. Open area, public space would get covered under 43. It's a broad classification. We'll delve deep into it. So 41, 42, 43. Now, in respect of 42, wherever there is a residential search, ensure that there is a lady officer accompanied. If the lady officer is not there, it is going to create a problem, and the lady officer should be empowered under the Act. Do not take a lady officer who is not empowered. So the empowerment becomes essential because of the fact that there could be a situation where you would be required to search the female occupants of that particular residence. So it is not simply a female who can search, it should be a female empowered officer. I'm stressing it should be female empowered officer who should be accompanying the team so that the case doesn't fail. If the officer takes a female officer who is not empowered and the search takes place and the recovery is affected from the female, the search shall be vitiated and the trial is going to fail. Now that becomes extremely important with reference to search and seizure. Now, conveyances, we do not use the word generally vehicles, we use the term conveyance. Vehicles are included in the broad category of conveyances. Conveyances can be stopped on reason to, if you have reasonable suspicion. Okay, now it is in movement, transit cases are getting covered, but public space, when we say public space, if a public vehicle, we mean a public vehicle which is government owned, say a bus run by a state government, which is on a public road. Public road is a road which is you can access, I can access, anybody can access. So public vehicle on a public road gets covered under 43. And see the sharp distinction I'm making. If it is your private car on a public road, the provisions of 43 will not apply. I'm making a small distinction here. A public vehicle, that is a government vehicle, that is a government bus or anything which is to do with government, in which you know that for sure that there is illicit drug trafficking happening, you can stop the vehicle and you can conduct the search and take action. In that situation, it is section 43, government bus on a government road. It's a public road. It's a national highway. It's a state highway where anybody can access the road. It is not restricted access. It's not a private road within a complex. If that is the situation, 43 will apply. On the same road, which is accessed by all public, but the vehicle is a private one. By private, I mean it is one's own car. That is, if it is my own car, if I'm driving on a particular NH8 or NH44 or NH200, the officer has to conduct the search only under 42. The provisions of 43 will not apply. These are things which are extremely minute in character, so it has to be kept in view while affecting others. Once the recovery takes place, we have to take a call with reference to what is the substance. So classification becomes extremely important, whether it falls under narcotic drugs, whether it falls under psychotropic substances, or whether it falls under controlled substances. So classification is another prism through which you can learn this act. And based on that, you will have to take out the field test kit or the drug detection kit to do it. It is not that you will be having a drug detection kit for all the drugs which are into the market. Overall, there are only three. One is for the precursor chemicals, one is for the ketamine, and other is for the other ones, the narcotic drugs. Apart from that, there could be any number of drugs which come to the market on a daily basis based on the illicit discovery, which is on running on a continuous basis. So you have to have reasons to record as to why you intend to seize it. So it should be very clear in your Panchnama or decision memo as to why you do it. In respect of these ketamine or any of the drugs for heroin or cocaine or methadone, etc., you have a detection kit which will give you a result on which you can make it happen. So that test report shall be binding. Initial test report shall be binding on the prosecution. So you have the reason to believe based on this. But in case there is something which is new, but it is not covered under the drug detection kit, but still you can seize it because you have the reasons to believe that it could fall under the ambit, and it is for the FSL, the Forensic Science Laboratory or the Central Revenue Control Laboratory to test it and let you know. It's quite possible. So this procedure which I'm elucidating from section 41, 42, 43, there are other sections which are extremely important. But these are the basic ones. And there have been plenty of cases wherein people do not carry in tons, but they do carry on in their purses. They do carry in small quantities, and they do carry in body cavities. So in such of those cases, it gets covered under section 50. So you will have to issue a notice to the person who is suspected. At that time, recovery is not there. It is suspected to carry drugs on his person. So you will have to ensure that the legal rights, the statutory rights which are conferred upon him or her under the act has to be explained in the language known to the person. This becomes extremely important. You may get hold of a person who speaks a language which is different from the language you know. So you will have to be extremely alert, and especially at the airports, international airports, or at places where there is a lot of movement of the foreigners. In case the officers do encounter this one, they will have to be extremely cautious that the language doesn't become a barrier. Now, what are the points under section 50? The first one is that he has an option to get himself examined in the presence of the nearest gazetted officer of the empowered departments or the nearest magistrate. He has to be given only these two options in writing. You can give the option orally, but oral communication has to be proved, and it is too difficult in NDPS cases to prove oral communication. It is always better that you give it in writing. Now, this has to be done in the presence of independent witnesses. And should there be a language barrier, there should be a translator or interpreter who would explain the contents to the person, and thereupon his remedy or his rights are explained to him, and he exercises that option on the body of that notice, and thereupon the officer takes action. In case if he exercises the option to get himself searched before the gazetted officer, it is the gazetted officer who is not forming the part of the team he should be taken to. If there is a gazetted officer forming part of the team, that gazetted officer is not an independent officer, so you cannot take him to that one. If the officer takes him to that gazetted officer, the case will fail only on the ground. So you will have to take him to an officer who is independent of the search team, or you will have to take him to the nearest magistrate. So the option is exercised by the suspect at the time. The moment recovery happens, the terminology would change. He would not be a suspect. He becomes an accused under the NDPS Act. So section 50 plays a vital role, and in that there is a provision called subsection 4, which talks about female suspects as be searched by female only. So this is one bold statement. As I told you in the beginning, and it is only an empowered female officer who is authorized to search the suspect. if you deploy somebody other than an empowered officer, the case will fail only on the ground, and grant of bail on account of procedural compliance is a stepping stone for acquittal. So this is a thing which has to be mastered. Now, there could be a situation wherein the gazetted officer is far away, and it is quite possible the section 50, which deals with notices, authorizes the empowered officer to take action on his own without the accused, without the suspect being produced before the gazetted officer, if he has reason to believe that he will part with the drugs. So why I'm telling you is there are drugs like LSD or MDMA which would entail a punishment. For example, MDMA, 10.01 gram would entail a punishment of minimum of 10 years. So 10 grams doesn't be is not a huge quantity for the purpose of carrying it sacks and bags. So it is carried in private parts, or it's carried in purse, or it is carried on purses, etc. So recovery in such of this condition requires a lot of proper thinking and proper compliances. Similarly, LSD is another item which is generally carried in purses, and it is also extremely likely that it is not carried in this huge quantities, but a gram of it is also sufficient to entail a punishment of 10 years. So depending on the drug, the small quantity are prescribed, small quantity, intermediate quantity, and the commercial quantity are prescribed. So we'll have to be very careful with reference to the procedure which has been set out. The other aspect which requires our attention is the Chapter 5A, which stood inserted by the Act 2 of 1989. It is in compliance with the obligations set out under the 1988 Convention. And one of the mandate of the 1988 Convention was to neutralize the ill-gotten wealth by illicit drug trafficking. So this particular chapter is dedicated to neutralizing the proceeds which have been ill-gotten through illicit drug trafficking, and primarily it focuses on the methods by which we do it. It would be applicable to certain sections of the accused, primarily who are dealing with commercial quantities, and whether he has in his own name or in relative's name or in associate's name, in whatever manner he has concealed it, it can be unearthed. But it is a post-investigative tool. It means that initial search has happened. The case under 42 is primarily conducted by officers who have been entrusted or empowered under 42, and subsequently it gets transferred to officers who are empowered under 53. Why this becomes important is in respect of some of the organizations, especially in state governments, an officer who is empowered under 42 is not empowered under 53. But that is not the case in respect of central government departments like NCB or DRI, Customs, and other formations. But here, there would be a lacuna here. That lacuna is exploited by the defense counsels. So it gets transferred to an officer under 53. The section 53 officer is entrusted to investigate the case. So it is mandated that he also would do a financial investigation, and he would give a report within 90 days from the date of seizure. That is under 57 capital A. But when you read this 57A in conjunction with Chapter 5A, Chapter 5A becomes applicable to a person who is convicted in NDPS Act. It means conviction is recorded after, say, 8 years or 9 years. Here it's 90 days vis-a-vis conviction being given by the trial court after, say, 8 years, 7 years, or 5 years, whatever may be the case. So hence, it is directory in nature. It is not mandatory. This clause, even though there is a period of 90 days, is set out under the Act, But in view of the fact that the chapter 5A itself defines the thing post conviction, so we have the leverage to use that provision to say that it is a provision which is directory in nature. All the action has to be initiated by the section 53 empowered officer by calling in records, by using his PAN number. The FIO would be certain, the income tax department, the sub-registrar where the land dealings are taking place, the NBFCs, the stock, the demat account. All these are financial documents which have to be scrutinized, whether it is in his own name or it is in the name of his associates or relatives. It has to be unearthed. The unearthing of the financial transactions which are disproportionate to the known source of income, legal source of income, has to be figured, and it should fall well within the ambit of 6 years backwards from the date of arrest. For example, today is 12th of July 2026. Should a case be made out here today and the officer finds that there's a lot of transactions, he has the time period from 13th of July 2020. If a property is purchased illegally, even on 1st of January 2020, it is outside the ambit of the NDPS Act. So it gives you only a leverage of 6 years from the date of arrest or seizure. So that has to be taken care of. That is under provisions of 68C subsection 2. So that is one of the most important provisions. The other provisions which require attention of the participants pertain to one particular section which deals with the Customs Act and the participants. Can you mute yourself, please? So there is an interplay between the Customs Act and the acts. So we'll be dwelling into that. So this is the definition portion which I had told you: narcotic drugs, psychotropic substance, and controlled substance. And we have this classification once again with reference to each of this which I had dealt with earlier. And this is one of the most important classification. We classify it based on the quantum of seizure. So it is either small quantity or commercial quantity, as has been defined under the Act. Section 2 defines small quantity and commercial quantity. And there is a notification which has been issued way back on 19th of October 2001, which keeps on getting amended. So based on that, we'll have to see the notification. There are two columns which merit your attention. One is column 5 and column 6, which says column 5 deals with small quantity and column 6 says commercial quantity. Both have to be read in conjunction with the definition. But if you read the definition, it says which have been notified in the Act and which are less than the amount specified. For example, the quantum of heroin is, if it is 5 grams and 255 is under the small quantity, 250 is commercial quantity. But if you read it in conjunction with the definition, 5, the quantum of seizure, if it should be less than 5. So it should be up to 4.9999 would be small quantity. Exactly 5 would be intermediate quantity. Similarly, in the column 6, 250 grams, which has been notified for the purpose of heroin, if it should be in exceeding the amount which is notified. So 250, it should be 250.001 or 250.01. Anything in excess of 250. So if somebody seizes exactly 250, it will be intermediate quantity. Why this becomes important is commercial quantity, the bail is covered under section 37, whereas other than commercial quantity, the bail is available not at the hands of the officer, but in the court. So if it is a case wherein the person is subject to commercial quantity cases, it is subject to the twin condition which has been laid down under 37. The twin condition being that the court will hear the PP. It has to hear the PP at any cost. It cannot pass any
गैस
order.
खत्म हो गया उनका
मैडम जरा म्यूट कर लीजिए.
भी बोले पाइप पे नहीं मैंने जैसे किसी कहीं आग लगा होगा जी हाँ, तो
मैडम
पूरा
आप जरा
सोसाइटी
प्लीज कैन यू म्यूट योरसेल्फ. Now, commercial quantity cases, the court is bound to hear the public prosecutor, and it will also record to the effect that he is unlikely to commit another offense of this kind. So that is a very difficult proposition, and hence we find that it is very difficult for the court to arrive at that particular thing. Now, regulatory authorities, I have already told you, the state governments and the central governments. The Narcotics Commissioner is there, the NCB is there, the state excise and the police departments are there. Now, offences and penalty I have dealt with in great detail, but I would like to specify one particular thing, which is a reference to one particular section, which is section 19. Why this becomes extremely important for the purpose of this session is opium poppy is legally grown in the states of Madhya Pradesh, Rajasthan, Uttar Pradesh, and parts of Uttarakhand on an experimental basis in Vikas Nagar and Dehradun in the state of Uttarakhand. So why this becomes important is the farmers are cultivating it on behalf of the central government, and numerous cases have been booked, and the word used in the act is embezzlement. A property, even though he is the cultivator, a legal cultivator, the property doesn't belong to him. The property belongs to the government. Government means central government here. And if he does an act of theft, that theft which he does on the property which belongs to the central government, it would be termed as embezzlement. And should he get caught, it invites a punishment, and it is treated on par with any other commercial quantity cases. It's a non-bailable, cognizable and non-bailable offense, and would invite a minimum punishment of 10 years. So embezzlement is a very serious charge which is leveled against a cultivator who diverts the opium sap or opium into the market for various reasons. So apart from this, there's a lot of other things. One other thing which I would like to focus is on cultivation. As against cultivation, we see two sections. One is section 20, which has two parts, 20A, small a, and 20B. 20A deals with illicit cultivation of cannabis. The cannabis is a plant. It's, as per the act, it is genus cannabis. In respect of opium poppy, it is a species. Species is the last ladder, and genus is one step above species. Now, species, as far as opium poppy is concerned, the species is specified as Papaver somniferum, and we get opium sap out of this and the district opium officer functioning under the supervision of the CBN Gwalior is tasked with the collection, and he is supposed to transfer it to the government alkaloid factory. Now, why this becomes important is the cannabis plant does grow on its own. This act is covering only conscious cultivation. It means that I should irrigate the field, I'll till the land, plow the land, water it, plant the seed, grow it, manure it, water it, take care of it. Only those process, if it is available, only then we have a case of illicit cultivation. Wild growth is outside the ambit of the Act. This is very, very important. So while officers do make out a case, we'll have to distinguish that it's a case of conscious cultivation. I knew it that I'm growing it. I knew that this is wrong, but I did it. So the officers have to bring on record that this is there. So this becomes important. Illicit cultivation, there's another huge difference is when the plant is there, and the plant may attain maturity by way of flowering tops and fruiting buds, but it continues to be cannabis plant until it is severed and transported. When it is transported, the entire plant, when it has the flowering buds and fruiting tops, it attains the name ganja. But when the same plant is attached to the earth, it is a cannabis plant, and the offense of cultivation gets covered under 20A, and there is no segregation of the cultivation, illicit cultivation, into small quantity or commercial quantity. When the same thing gets severed and the entire plant is to be taken for the purpose of ganja, and there is no requirement under law to segregate the weight. And this is one area where the officers have to be very careful. This is that area. And when it gets covered under the concept of ganja, the gradation of quantity becomes important. If it is less than 1 kilo, it is more than 20 kilos. More than 20 kilos, it becomes commercial. It becomes a non-bailable offense, and the court will hear the person subject to the condition that he fulfills the provisions of 37. So similarly, under 18 also, even though it is not listed, illicit cultivation is not specifically listed. When we read the notification of 19th October 2001, read with note 4, we can classify it under clause C of section 18. So here also the cultivation, illicit cultivation attracts a punishment up to 10 years. So 20A, small a, and 18C, small c, are the provisions for illicit cultivation of cannabis plant and opium poppy. So these are two things which requires your attention. And one more thing which requires your attention for the purpose of this PPT is that a person sitting in India can orchestrate something elsewhere, or a person of Indian origin holding an Indian passport can sit in a different country, can do it, can indulge in illicit drug trafficking. A person sitting abroad can also be brought well within the ambit of external dealings. It is not necessary that a person should sit in India to indulge in illicit drug trafficking. He can sit abroad and do it and also get covered. So section 12 would be read into it, and the punishment prescribes that he can be prosecuted and he can be punished under 24. So external dealings are there. There could be a situation where he is sitting here and is orchestrating somebody else sitting elsewhere, say Australia, to ship drugs to somebody in US. That is what the Operation Medmax is all about. So there also he gets the same punishment. Sitting here also, he can, without touching the drugs, without doing anything, also he can get punished. So 41, 42, 43 I have covered. And how this is one of the reason of 42, this becomes a very important deep dive for the purpose of this is every information, whether it is received from whatever source, has to be recorded in writing. That is the first thing. All 42 deals I told you with the non-custody officer, they have to reduce the information to writing, and they have to invariably submit it to an immediate official superior. And while doing so, the gist of the information should be brought out very categorically, and it should have its name, designation, time, and date. Time plays a very important role in NDPS Act. So you will have to be extremely cautious, and based on that, it has to be transmitted. The registers are not prescribed in the Act, but you will have to prove in the court so that the movement has been proper. So you will have to take to the internal mechanism of that particular organization for the purpose of movement of the intel from the desk of a non-gusted officer to the desk of the gusted officer, how it has been moved. So that has to be taken care of. The gusted officer who receives the information or the immediate officer who receives the information will go through it and will come to a satisfaction. There is a case made out, the information is actionable in nature, and he would then process it for the purpose of issuance of a authorization if he is a gusted officer. Otherwise, he will pass on it to his immediate superior, who is a gusted officer. So in the CBSE formations, the inspector puts up the thing to, or the sub-inspector directly processes the information and it submits to the superintendent, who is a gusted officer, for the purpose of this section. This is one. What happens if a gusted officer receives the information? It's not necessary that every time only the non-gusted will be receiving it. The Act says that any officer who receives information, this is general neuter, any of irrespective of the position one holds, he or she has to reduce the information into writing. So in case of non-gusted officer, it will go up the ladder to his immediate boss for the purpose of issuance of a search authorization. In respect of a gusted officer who receives it, it will flow to the immediate junior who will be implementing it. But the requirement of reducing into writing is not dispensed with either way. So requirement is extremely crucial. And what about these days with the change in mode of communication? You may receive the communication via email too. So there also you will have to reduce it. It is, if it is addressed to a particular person, particular officer, or a particular head of the department, he or she who operates that legally has to do it. So you cannot authorize, you cannot ask his PA or PS to do it. So that will be a violation of this. So 50 I have covered, and the information I told you, the standard investigation flow is there. Information is reduced in writing, then seizure takes place. Then apart from that, then you will have to move the magistrate for the purpose of sampling. That is under 52A. It is mandated that the sampling has to take place in the presence of judicial magistrate, not executive magistrate, for which you will have to move an application. And after that, one more important function of the empowered officer is that he has to give a report on search, seizure, and arrest to his immediate boss. And these are all mandated, and these are all required to be, timeline have to be adhered to be very, very strict timelines are there. You cannot exceed the timelines as prescribed. So timelines are very, very crucial in respect of these operations. Now, this is the purpose I told you, mandatory reporting of search and seizure. So it requires extreme caution on the part of the officer, and electronic evidences are the flavor of the season. So erstwhile, prior to 1st of July 2024, it used to be 65B certificate under the Indian Evidence Act. These days, it is under 63, subsection 3 of the Bharatiya Sakshi Adhiniyam. So that has to be complied with. So electronic evidence which is not in compliance with 65B4 or 63.3 of the BSA would fail. So it is a duty which has been cast on the empowered officer to ensure that these are strictly adhered to. So what are the 10 golden rules I have made out for this presentation? All the information which is received have to be jotted down, reduced into writing, submitted to immediate officer. And if you are issuing a notice under 50, inform the legal rights or the statutory rights which has been conferred upon the suspect, and weigh the packages properly. If it is, you are weighing along with the packaging material mentioned in the gross weight. Otherwise, if it is net weight, make a distinction between gross weight and net weight, because weight will tilt this way or that way. If you write net weight of 10 grams, of MDMA or gross weight of MDMA as 11 grams, both would operate on two different this one. So you will have to detect the packaging material, and you will have to draw the sample in the presence of magistrate. You will have to forward it to the FSL or the CRCL within the time limit of 72 hours. You will have to secure a valid 63(3) certificate. You will have to conduct the operation in the presence of the independent witnesses. In case you are unable to do it, you will have to record the reason as to why you were not successful in procuring the independent witnesses. It could be a case wherein the operation is conducted at midnight. Witnesses are unavailable. So it depends on the lot of other factors. And sampling has to be certified by the judicial magistrate. And that includes not only the contraband, but also the conveyances which are used. Conveyance means which are used for the purpose of trafficking. So it has to be photographed, the engine number, the chassis number, etc. They would be along the registration number would also be taken photographed, and that would be done. And maintain chain of custody. This chain of custody is equally applicable for contraband and equally applicable for electronic evidences. So the chain of custody is one of the important cushions for the purpose of this act. And at last, I told you the arrest report under 57A, search seizure arrest report has to be given within the mandated period of 48 hours. So the NDPS Act acts on a strict timeline. So it has to be followed, and there is no deviation from this act. Now, why this becomes important for us to understand? Because of these factors. The Act balances strict deterrence. If it is for medical uses or for scientific purposes, the Act makes an exemption, but it is not otherwise. The classification based on quantity becomes important. So it is the net weight which counts, not the gross weight. So materials which are used for packing, etc., should be discarded for the purpose of arriving at the net weight, because it will tilt. For example, MDMA 10.01 gram is commercial quantity for the purpose of this act. If the gross weight is 10 grams, obviously a case would be fought in the court, not for other reasons. It will tell that, sir, this is a case which falls under intermediate quantity. If you take out 1 gram of it, it becomes 9. Packing material is in the pouch, and pouch is 1 gram. So 10 minus 1 is 9. So we will have to be sentenced accordingly. So it falls under a different category. Category changes. So category changes, the bail provisions will change. So it is very important to understand. And here the act is on a very different footing. It is a reverse burden which is cast on the accused, and it is for him to prove that he has not committed this offense, provided the foundational facts are laid down by the prosecution properly, and it is for the accused to rebut the presumption under 54 of the NDPS Act. And one of the beautiful provisions of the NDPS Act deals with Chapter 5A, which deals with forfeiture of property, and officers who are to follow a set protocol, and the protocol cannot be violated. The timelines have to be adhered to. So that is the key takeaway from this. The floor is open for any questions which may arise in the mind of the participants.
What is the differences between the drugs and substances? The psychotropic substances, they are not even touched. What is the differences between the drugs, narcotic drugs, and psychotropic substance?
I did touch it in the beginning. Narcotic drugs, I told you, you will have to see it from the perspective of the NDPS Act. So do not confuse this term.
No,
with
substances means. Substances means.
When I'm answering, just don't interrupt, please.
Yeah.
Narcotic drugs are those substances which are notified. See, everything is notified for the purpose of this act. Okay.
Yes.
Now, how this becomes extremely important for your understanding is there are 3 plants to it. I told you cannabis plant is there. There is opium poppy. There is a coca plant. So now coca is not grown here because of the climatic condition. It can't be grown here. That's a different issue altogether. We have cannabis plant and we have the opium poppy. From opium
Okay.
poppy, we get opium sap or opium gum, from which we derive lot of alkaloids. Now, what do you
Yes.
derive from this plant?